Good morning. Good morning, everybody.
Good morning, everybody.
She wants to say hi again. Can you say, everyone have a good day?
Everyone have a good day.
What do you think? You're on TV. All right, say bye.
Bye.
Okay. Morning, sir. Can I get your full name?
Morning, my name is Isaiah Philip Camacho.
Mr. Camacho, I'm just seeing you for another review hearing for your Maricopa County warrant. Looks like you're still pending your local matters here, so we'll just set another review hearing for about 30 days to see what's happening. We'll set that for January 30th at 9 o'clock in the morning. All right.
Okay, thank you.
All right. You're welcome. You're excused.
Sure.
Good morning, Your Honor.
Good morning.
Hello.
Hey, ma'am. Can I get your full name?
Roxanne Renee Perkins.
Ms. Perkins, I'm seeing you for a review hearing for your Santa Cruz County warrant. It looks like you've wrapped up your local matters here. Is that right?
I believe so.
Okay. 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 All right. So it sounds like they're just waiting for Santa Cruz.
Okay.
But let's set a review hearing in a week to make sure that that's happened. We'll set that for January 6th. All right.
Okay.
All right. You're excused.
Yes.
Hello.
Sir, can I get your full name?
Bernard John Serficio Jr.
Mr. Serafisio, I'm seeing you again for your review hearing for your Maricopa County warrant. Looks like you're still pending your local matter, so we're just going to set another review hearing in 30 days to see what's going on with those, okay? So that'll be January 30th at 9 o'clock in the morning.
Okay.
And your excuse, sir. Thank you.
Always nice for first. Collins, come on up, Jim. Brown shirt. Everybody else have a seat.
Good morning, sir. Can I get your full name?
Andre Collins.
Mr. Collins, I'm seeing you this morning on a charge of domestic violence, disorderly conduct. You do have the right to remain silent. Anything you say can and will be used against you. Sir, I am going to release you on your promise to appear in court. And pretrial services was not able to speak with the alleged victim, looks like your father. So I don't know what his position is. If you were to return to his house and he doesn't want you to be there, you need to go somewhere else. Do you understand that?
Got it.
All right. I'm also ordering no alcohol or illegal drugs, no acts of domestic violence, and you need to be in Oro Valley City Court on February 5th at 10:30 in the morning, or a warrant can issue for your arrest. Do you understand? All right, you're excused.
Blackville. Oh, we out there? Or look outside.
Hey, sir, can I get your full name?
No, doing that, Contreras.
All right, Mr. Landerville Contreras, I'm seeing you this morning on a few different matters. You've got a warrant out of Mammoth Oracle Justice Court for a very old case from 2016, disorderly conduct, and it looks like assault. And then there was at least one failure to appear charge in 2020. And then you've got some warrants out of Tucson City Court as well. Both of them are from October of this year. There's a theft and drug paraphernalia charge from October 23rd, and then a disorderly conduct drug paraphernalia charge from October 24th. You were released on those charges, but then you did not go to Tucson City Court to take care of them, so warrants issued for your arrest. Where are you living right now, sir?
Oh, I'm staying with a friend.
In Tucson?
Yeah. Before I didn't have a stable, like it was not, my life was not stable, and I did miss those court dates.
Okay. So if I release you, are you going to get to court?
Yes, ma'am.
And you're going to call the Oracle Justice Court to take care of that old matter?
Yeah.
Right. So on that one, I'm going to order that you be released on your promise to appear in court. They gave me a court date of January 6th at 10:30. You want to call them when you get out. Their information is going to be on your paperwork, but make sure you call them when you get out and make sure that that's a good court date still, and see if, if you can't make it up there, see if you can appear by video. All right.
Okay. Okay.
All right. And then on your Tucson City Court matters, I'm also going to order that you be released on your promise to appear there. I'm ordering that you possess or consume no alcohol or illegal drugs, that you not return to any incident location, and your court date in city court for both of these matters will be on January 30th at 2:30 in the afternoon. All right, you are going to get paperwork with that information on it. Do you understand?
Okay.
All right. You got to get to your hearing so that warrants don't keep issuing for your arrest, okay?
Thank you.
All right, you're excused.
There's no talking in the courtroom.
Your Honor, this is Court Interpreter Pedro Davis. Can you hear me?
Yes, hi, Mr. Davis. Looks like,
Yes, I'm looking at the list. I don't see any people identified as Spanish speakers.
I don't either, so you're excused. Thank you.
Thank you very much.
Hi, ma'am. Can I get your full name?
Jessica Martin.
Ms. Martin, I'm seeing you this morning because you have a warrant out of Pima County Justice Court for driving on a suspended license charge from January 7th of this year. You're being held without bond currently on your Superior Court probation violation, so you're not going to be released today. You're going to go to Superior Court probably sometime in the next week to deal with that probation hold. As to this Justice Court matter, I'm going to order that you be released on your promise to appear in court. If you are out of custody, you need to make sure that you get to Justice Court on January 29th at 8:30 in the morning. If you're still in custody on your probation violation, they'll take you to a video hearing on that. And if you were to be released, I'm also ordering that you do not drive without a valid driver's license. Do you understand all of that, ma'am?
Yes, I was scheduled to work this week, so
There's
I guess
nothing, yeah, there's nothing I can do about your probation hold. That's got to be dealt with in Superior Court. All right?
okay.
All right, your excuse, ma'am.
Okay.
Anything.
Hey, sir, can I get your full name?
Mike Amos.
Pretrial services, I don't have a report for Mr. Amos.
Okay, let me see. One moment. Okay, let me set that one to review really quick.
Yeah.
Okay, it should be available.
Thank you. All right, Mr. Amos, I'm seeing you this morning on a couple of charges from November 26th of this year. They're domestic violence, criminal damage, and disorderly conduct. You do have the right to remain silent. Anything you say can and will be used against you. I'm going to advise you that you're ordered to appear at all of your hearings. If you miss your hearings, they can go forward in your absence. Warrants can issue for your arrest. And if you're convicted at a trial and you can't be sentenced within 90 days of the conviction, you could lose your right to a direct appeal. I'm going to enter pleas of not guilty for you at this time. So, sir, I am going to order that you be released on your promise to appear in court on these charges. Pretrial services has information that you're also pending a Superior Court domestic violence case involving the same alleged victim. So let's be really clear. You are to stay away from, looks like her name is Genesee. Do you understand?
Yes.
All right. So that means you can't call her, you can't text her, you can't go to her residence or workplace or any other way to contact her. Do you understand that?
Yes.
I'm ordering that you commit no acts of domestic violence, and then you need to be in court, Tucson City Court, on February 4th at 9 o'clock in the morning, or a warrant can issue for your arrest. Do you understand that?
Yes.
All right. And just to let you know, your girlfriend, fiance is here present on your behalf. All right.
Yes.
All right. Your excuse, sir.
But. Not sure.
Oh.
Hi, ma'am. Can I get your full name?
Rachel Carbuck.
Miss Buck, I'm seeing you this morning because you have some new charges of criminal trespass and disorderly conduct, and then you've got a warrant out of Tucson City Court for criminal trespass from December 14th of this year. So you have the right to remain silent. Anything you say can and will be used against you. I'm going to advise you that you're ordered to appear at all of your hearings. If you miss your hearings, they can go forward in your absence. Warrants can issue for your arrest. And if you're convicted at a trial and you can't be sentenced within 90 days of the conviction, you could lose your right to a direct appeal. I'm going to enter pleas of not guilty for you on the new charges. Ma'am, where are you living right now?
Well, I was living with a friend because I was trying to find out, because on Friday when I went to court, I was supposed to go that day. I was supposed to go, had scheduled to go get my ID and a couple other things, like phone stuff. And then I missed it, so I had to schedule it for this week. And I was trying to do it all week, and I got my ID. I got a copy of my ID, and I was staying with a friend, and we're trying to, get me a place. And he just works during the day. And it's like, just trying to get me supporting.
And do you go anywhere for behavioral health treatment?
Not right now.
Where had you gone before?
La Frontera.
La Frontera?
Yeah.
All right. So if I were to order that you go and get a behavioral health assessment, would you do that?
Sure.
All right, I'm going to order that you be released on your promise to appear in court. I'm ordering that you possess or consume no alcohol or illegal drugs, and that you not return to the incident location from either. I don't know what the first one was from a couple of weeks ago, but this one is it's on 2450 East Grant Road. I'm not sure what store that is, but you can't go back there. Do you understand that?
Yeah.
All right, and I'm going to order that you get a behavioral health assessment. And then you need to be in Tucson City Court on February 3rd at 2:30 in the afternoon with Judge Cranshaw, or a warrant can issue for your arrest. Do you understand?
Mm-hmm.
All right, ma'am, you're excused.
Jose Lopez.
Hi, sir, can I get your full name?
Jose Manuel Lopez.
Lopez, I'm seeing you this morning because you have a warrant out of Tucson City Court for criminal trespass and obstructing a drain channel. Those are from November 27th of 2022. You do have a hold out of, it looks like you've got a probation hold out of another jurisdiction. You're being held without bond on that. You're going to need to go to that jurisdiction to take care of that matter. So as to this one, I'm going to order that you be released so that you can get picked up and deal with that there. And then we'll set your hearing in Tucson City Court for February 7th at 9:00 in the morning. And you need to get to that hearing on that date, or warrants can issue for your arrest. Do you understand, sir?
Yes, ma'am.
Okay, you're excused.
Thank you.
McFerrin.
Hi, sir. Can I get your full name?
Sheldon McFerrin.
Mr. McFerrin, I'm seeing you this morning on 3 counts of domestic violence, disorderly conduct. You do have the right to remain silent. Anything you say can and will be used against you. I'm going to advise you that you're ordered to appear at all of your hearings. If you miss your hearings, they can go forward in your absence. Warrants can issue for your arrest. And if you're convicted at a trial and you can't be sentenced within 90 days of the conviction, you could lose your right to a direct appeal. I'm going to enter pleas of not guilty for you at this time. It looks like pretrial services did speak with it just says Miss McFerrin, so I don't know which Miss McFerrin that is, but she said that she does not want to have contact with you and that you can't return to the residence at this time. It also looks like you've got another city court case that's pending right now with this, at least one of the same alleged victims.
Yeah.
So, sir, if you could not return to your residence, do you have somewhere else that you can go?
No, I don't have any family out here. My sister, she's in an assisted living home. It's my house. That's what I'm trying to explain to you.
Well, that's not, the court can't take up that issue. The fact of the matter is she resides there, she's staying there right now, and you can't go back there. So you need to find somewhere else to go.
Okay. That's all I can do then.
All right, then I'll order that you be released on your promise to appear in court. I am ordering that you possess or consume no alcohol or illegal drugs, that you commit no acts of domestic violence. I'm ordering that you possess no firearms or weapons, and that you have no contact of any kind with both your wife and your stepdaughter. Do not return to the residence. I will put in my order that you can go back one time with a law enforcement escort. So you would take my order to the nearest police station and have them go with you to get your things. You understand that?
Yes.
All right. And then you need to be in Tucson City Court on January 28th at 3:00 in the afternoon, or a warrant can issue for your arrest. You're going to get paperwork with all of that information on it, right, sir?
Thank you very much.
You're welcome. You're excused.
Mary?
I'm getting them both, but it pops up in jail rec. It gives me an error message and just.
All the way out, sir.
Hi, sir.
I'm check. Side.
Hi, sir.
Hello.
What's your name?
Jordan Merrick.
Mr. Mary, I'm seeing you this morning on charges of assault, disorderly conduct. Those are both domestic violence offenses. You do have the right to remain silent. Anything you say can and will be used against you. I'm going to enter pleas of not guilty for you at this time and advise you that you're ordered to appear at all of your hearings. If you miss your hearings, they can go forward in your absence. Warrants can issue for your arrest. And if you're convicted at a trial and you can't be sentenced within 90 days of the conviction, you could lose your right to a direct appeal. I understand that we've got a victim on the line in this matter. If you're here for the Jordan Mary matter, if you could please unmute yourself and tell me your name.
Brianna Lindholm.
Okay. Ms. Lindholm, what would you like me to know?
I just got the phone number. I'm sorry. I just jumped in the call. I did a singing and I was asked if I wanted Jordan to be able to return home, and I do. It's all happened in September, and it was a verbal argument, so I don't know why it's being said he assaulted me. He did not put his hands on me, and last night he was protecting me from the girls outside. We were downtown. But he's never heard anything. He's never ever heard me.
This sounds like a different incident than what you're talking about. It says the ticket, just so that we're all clear, says that on September 17th that you two got to an argument over the price of laundry at their apartment, that you argued, that Jordan grabbed you by the shoulders, shook you, and said you work at a bank and you're not good at math, and then he fled the scene and you had bruise marks on your shoulder.
I did not have bruise marks on my shoulders. He never grabbed me or shook me. I guess we did have an argument about laundry at some point, but it was no big deal. And we didn't even break up over that. We just celebrated Christmas together with both our families.
All right. So thank you, ma'am. I appreciate it. I am going to order, sir, that you be released on your promise to appear in court. I'm ordering that you commit no further acts of domestic violence. And then you need to be in Tucson City Court on January 28th at 3:00 in the afternoon, or a warrant can issue for your arrest. Do you understand that?
Tucson City Court at January 28th at 3:00 in the afternoon, ma'am.
Yes, and you're going to get paperwork with that information on it. And ma'am, you can appear at that hearing as well and talk to Judge Millian about your position on it. Okay.
Thank you, ma'am.
All right.
Thank you.
All right. You're welcome. You're excused, sir.
Brad. Oh, yes.
Hi, sir. Can I get your full name?
Frank Bernard Pratt.
Mr. Pratt, I'm seeing you this morning on a couple of different matters. You've got new charges of domestic violence, criminal damage, and 2 counts of disorderly conduct. And then you also have a warrant out for your arrest for similar charges that are alleged to have occurred November 27th of 2023. And it looks like you had been to court on those charges. They're also domestic violence, disorderly conduct, criminal damage, threats, and intimidation. You had appeared in court, but then did not appear at later court dates, at least in March. And so a warrant issued for your arrest. As to the new charges, you do have the right to remain silent. Anything you say can and will be used against you. You have the right to an attorney. I will appoint the public defender's office to represent you. I'm going to enter pleas of not guilty for you and advise you that you're ordered to appear at all of your hearings. If you miss your hearings, they can go forward in your absence. Warrants can issue for your arrest. And if you're convicted at a trial and you can't be sentenced within 90 days of the conviction, you could lose your right to a direct appeal. Sir, I'm going to order that you be held on a $1,500 cash or secured bond. If you were to post that bond, I'm ordering that you possess or consume no alcohol or illegal drugs, that you commit no further acts of domestic violence, that you possess no firearms or weapons, and you have no contact of any kind with the alleged victims, in this case, your wife and your stepdaughter. Ordering that you not return to their residence. I will put in my order that you can go back one time with a law enforcement escort. So if you do post that bond, you can take my order to the nearest police station and have them go with you to get your things. And if you're still in custody, you'll be seen by video on January 8th at 1:30. If you were to post that bond, you would need to get to Tucson City Court on that date, or warrants will issue for you. Okay, then you'll. Okay. All right, so you're gonna be seen by Judge Millian on the 8th. That's all, sir. You're excused.
At what time, Judge?
Oh, sorry. I'm sorry. Hold on just 1 second, sir. I'm sorry. I forgot that we had a victim on the line. Did you want to say anything else, ma'am?
I want to know what time on January 8th?
January 8th at 1:30 in the afternoon. 1:30 in the afternoon.
One other thing is jail. I mean, I want him to stay until the 8th, but that's not helping him. He needs to get back on his meds. He needs counseling, and he needs a job. And that's all I'm asking. He did that court order. He could come home. Me and his daughter, we just did the holidays. It's been touch and go, but I cannot have Mr. Pratt destroying our home.
Right, and he was
so,
ordered. He was ordered at on the last case not to have any contact with you.
This is what happened. I don't know what happened last time, but when he went to court, I appeared, and they gave him a $2,200 bond and said it was for assault, which it was not. And so they let him out. We didn't even know he was coming. I mean, all of a sudden we saw him up the driveway.
And my charges were dropped, so I didn't go there.
Okay, well, so he's going to stay in custody.
Your Honor, he didn't, we're in the middle of saying that the charges that he has, the original charges that he has now, that the state was picking them up. So I had already let him back in the home because I felt like there was no reason when they let him out and dropped the assault charges and all that, he had no charges. And I got the paperwork in the mail. I can't keep him out of the home. And so I let him back in with the promise from him that this would never happen again. I can deal with anything else, but destroying the home, we can't. And this was a promise from his own mouth. This would never happen again. And this is why he's in jail again now.
All right, thank you. I appreciate it, ma'am. So he is going to stay in custody, and he is ordered to have no contact at this time with you or your daughter. And then you should appear in court with Judge Millian on the 8th so that you can let her know what your position is. All right? All right.
Take your lunch somewhere else. I'm sorry.
Yeah.
Thank you, ma'am. You have a nice.
Thank you, ma'am, for being here. Thank you.
Sit in the brown chair to your left. Sure thing.
Hi, sir. Can I get your full name?
Easy. Elexton Michael Jankowski. You know how to spell that?
I've got it. Thank you.
You're
Mr.
welcome.
Jankowski, I'm seeing you this morning on some charges of domestic violence, aggravated assault with a firearm, and 2 counts of animal cruelty. You do have the right to remain silent. Anything you say can and will be used against you. You have the right to an attorney. I am going to appoint the public defender's office to represent you, and you've got counsel seated next to you for today's hearing. I understand that we have a victim on the line. If you could please unmute yourself and tell me your name.
Hello, my name is Brianna Kamen.
Okay, and what would you like me to know, ma'am?
I wrote down a little note on paper here. I'm gonna read it. Excuse me. Due to the fact that he is an untreated schizophrenic, he's also autistic. He's a danger to anyone. He's poisoned my animals in the past, threatened to poison my fiance as well as myself. I've had some time where I thought that I was poisoned and I got over it, but he's got charges for assault against my fiance. He also threatened to burn down our house if I kicked him out. He might have more guns, I don't know. I'm asking the court he not be released until he can find another home. And if he can be court ordered to take meds and not carry firearms. From now on, I'm taking all his threats seriously. I do not want him at home. 3 animal accounts of cruelty because he shot all of them multiple times.
Your Honor, it sounds like the victim's being fed information.
They're both victims. I believe it's both.
Thank you.
All right. Thank you. I appreciate it very much, ma'am. All right. I'll hear from the state.
Your Honor, in this case, again, as the victim did state, this person has been charged with assault with a firearm multiple times. She's apparently shot 3 dogs. 1 is dead. And then in the space of this incident, he also pointed the weapon that he apparently had just discharged at his mother after shooting the animals. That and given the victim's statements, Your Honor, the state has very strong concerns regarding this person and would recommend a $10,000 bond plus PTS if it is posted.
Thank you. I'll hear from defense.
Yes, Your Honor. So given the nature of the charges, I understand the court might be inclined here to place a bond. If the court is going to do so, I'd ask that you do so with a nominal amount given Mr. Jankowski's current financial situation. He's obviously a young man here, and the information we have is that he's not currently working. Given, I think, the mental health nexus of this case, I can certainly appreciate the charges, but I think given the circumstances, a nominal bond is warranted here, Your Honor. The information that we heard today from the listed victims, much of that, it sounds very serious, but it's unfortunately unrelated to the charges at hand here today. I don't know the sequence of events. All I have is the complaint. It's not clear to me in what order things happened, though I will note that the pretrial services had contact with Mr. Jankowski's mother, who said that she would like to have further contact, and she did not sustain any injuries here. And so I think that's important for the court to take into account when coming to the bond conclusion here.
Can I say something?
Sure.
I had thought about it, and I would prefer that if he needs to contact us, that he contact my fiance instead of me.
Okay. So I'm going to order a $25,000 bond. It'll be cash or secured, released to pretrial services if that bond is posted. No acts of domestic violence, no firearms or weapons. If you still possess any firearms or weapons, those need to be surrendered. Ordering monitoring or treatment as directed by pretrial, and no contact at this time with your mother. So you want him to be able to contact you through your fiance?
Yes, I have a feeling he doesn't have any place to go. He's going to be homeless, and he's got some other thing. It's called it's for, I forget it, but it's called he has a hard time eating and gaining weight, so that might be detrimental to his health. Something about survival. He's got a medical thing on that. Failure to thrive. He's got that. So if he's homeless, he's going to be walking the streets, and then he's not going to be able to eat, and then he's probably, who knows what he's going to do. He's probably just going to waste away. So, but he can't come back here. He just can't.
Okay, what's your fiance's
Maybe
name?
a group home. Jerome Davis.
Okay. So I'm going to put that in my order that Mr. Jankowski, that you could contact if you need to have contact with your mother, that it be telephonically through her fiance, Jerome. Do you understand that?
Aye.
Okay. All right. So there's a preliminary hearing date scheduled for January 9th. I don't expect that hearing is going to happen on that date. I expect that there will be a hearing at a later date. And so you're going to be in contact with your attorney, and they're going to let you know when that hearing is going to be. And then, ma'am, if you could, if you want to appear at his future hearings, and you can also contact victim services to fill them in on everything that you've told me today. This is all I can do today. I can't, this isn't sentencing or anything, so I can't order any kind of, treatment specifically. I'm ordering that he get a behavioral health assessment, but that's going to be up to the jail whether or not that happens at this time. So as to what happens in the future, that's it would be good for you to be at those hearings and or contact victim services so that you can make sure that whatever information you have is given to the judge that handles this case. All right.
Okay.
Oh, and I'm also going to order one other order
All right.
that you possess no animals.
That me?
No.
I'm sorry. That he?
Correct.
Okay.
All right. All right. That's all,
And
sir.
he is going to stay in jail?
He's going to stay in jail unless he posts a $25,000 bond.
Okay, thank you.
All right. Thank you. Your excuse, sir.
Take care.
That's too far. That one's there.
Hi, sir. Can I get your full name? Mr. White, I'm seeing you this morning on a number of different matters. You have a charge of domestic violence, criminal damage. That is a new felony charge. And then you also have a new misdemeanor domestic violence, criminal damage charge. You do have the right to remain silent. Anything you say can and will be used against you. You have the right to an attorney. On the felony matter, I'm going to appoint the public defender's office to represent you, and you've got counsel seated next to you for today's hearing. You've also got, sir, some domestic violence warrants from 2019 cases out of Tucson City Court. So we'll deal with each of these cases, starting with the felony charges. The state is asking for a $2,500 bond. I'm going to enter pleas of not guilty for you, sir. $2,500 bond on the felony plus pretrial services. Did defense want to be heard on that?
Yes, Your Honor. Taking a look at the complaint here, it's not clear to me how we've reached the criminal damage charge that the state is alleging. It's just handwritten in damage over 1,000. There's no, discussion of how they reached that value number, who was contacted, who's the homeowner here. If the listed victim is the homeowner, I would expect to see that in the complaint, and she's not listed as such. So I'm not sure that that damage number is accurate. And furthermore, Your Honor, pretrial services got in touch with the alleged victim here, who not only welcomes him back home and contact, but notes that Mr. White is disabled. He's, I don't think in a position to receive the level of care and support that he needs if he is held in jail on a $2,500 bond. So I don't think it's very clear that he is currently working or has any means to pay a bond, and his financial circumstances is something that the court must take into account. So given the circumstances here, the fact that the alleged victim hasn't suffered any injuries, welcomes him back home, and given his circumstances around his physical and mental health and financial situation, I would ask that you release Mr. White to pretrial services. I would note, Your Honor, that those 2019 matters out of the city court, it appears to me that those have been wrapped up. He's already been terminated from probation in both of those cases. So I don't know if those warrants are still truly valid and active or not.
The last minute entries in those files from 2022 saying that he hadn't completed his groups at La Frontera and he was closed out at La Frontera due to lack of contact. So that was the last that he was, that those cases were dealt with.
I'm looking at the history from pretrial services, and for the case ending in 5689, it says that probation was completed on May 18th, 2023. And for the other case, the one ending in 1276, it says on May 12th that probation was terminated. So I see that there's dates on that January 20th, 2022, but it seems the information I have is that there was something that occurred after the fact in which his probation was terminated.
Is there any way for us to see anything? Yeah. Yeah, because I see what he's saying is accurate. It looks like there's paperwork missing in here. All right, that's all right. Thanks. So, Mr. Poston,
Your Honor?
so I'm looking at he's got a felony interim complaint with the exact same wording as that's on the probable cause statement on the misdemeanor, but then they just have written in damage over $1,000. I have no
Indeed,
idea.
Your Honor.
No idea
The
how
state
many.
has,
Yeah.
the state has no more information than you do. State submits on the record.
All right. Okay. I'm going to order release to pretrial services supervision. I'm ordering that you commit no further acts of domestic violence, no alcohol or illegal drugs, and I'm ordering that you go get a behavioral health assessment. So if you had been previously going to La Frontera, it seems like that would be a good place for you to go back. Okay, good. All right, and then preliminary hearing date is scheduled for January 21st. But sir, that hearing is very likely not going to happen on that date. On the felony charge, you're going to get a hearing at a later date. So you need to make sure you're in touch with pretrial and with your attorney so that you know when to get to court. And then on the misdemeanor charge, I'm going to order release. And your hearing date there will be January 29th at 10:30. That one you do need to get to on that date or warrant an issue for your arrest. And then yes, you're gonna get paperwork with all of this information on it. And then on your city court matters, I'm gonna still give you a court date on those to figure out what's going on because there obviously was still warrants outstanding for you on those. So I'm gonna still give you a court date on them. That is going to be January 9th. Wait, I'm sorry, February 4th at 9:30 in the morning. All right. That's all, sir. You're excused.
Oh, you're
All the way around, guys, all the way around, go all the way around. Thank you. Aliyah, you're up, sir. Right there.
Hey, sir, can I get your full name?
Rinaldo Badilla.
Mr. Vadia, I'm seeing you this morning on some felony charges of possession of narcotic drugs, possession of drug paraphernalia. You do have the right to remain silent. Anything you say can and will be used against you. You have the right to an attorney. I will appoint the public defender's office to represent you. Also seeing you on a warrant that you have out of Tucson City Court for a very old case from 2017. It says it's for domestic violence and assault, and it looks like you did not go to your arraignment, and so a warrant issued for your arrest. Did you know that you still had that pending?
No.
Right. Where are you living right now? Are you interested in getting housing?
Yes.
All right, so there is the Pima County Transition Center is a trailer that's right outside of the jail. So you can stop by there. I'm going to release you. You can stop by there and talk to them about getting housing, and they can help you out getting a phone and things like that, right? So, and then on these felony drug charges, it looks like you've got no felony history at all. You're very likely eligible for a drug diversion program, where if you go to court and you participate in some drug treatment, you could possibly have these charges dismissed before they're ever formally charged, which would be a really good thing for you considering your lack of history. Are you interested in that?
Yes.
Great. So we're going to set what's called a smart court hearing. That's going to be in 1 week from today, January 6th. at 9 o'clock in the morning, Pima County Superior Court. You have to get to that hearing so that you can participate in that program. And counsel waive time for the PH.
Yes, Your Honor.
That'll be February 13th. I'm releasing you to pretrial services supervision, so you need to make sure that you get in contact with them when you get out. Ordering monitoring or treatment as directed by them, no alcohol or illegal drugs. All right, and then on this Tucson City Court warrant, I'm going to order that you be released on your promise to appear in court there. Ordering that you commit no acts of domestic violence. And then you need to be in Tucson City Court on February 6th at 9 o'clock in the morning, or a warrant can issue for your arrest. Do you understand that, sir?
Yes.
All right. You are excused.
Thank you. Dylan Barnes.
Hey, sir, can I get your full name?
Dylan Barnes?
Mr. Barnes, I'm seeing you this morning on charges of theft of means of transportation, criminal damage, and 6 counts of endangerment. You do have the right to remain silent. Anything you say can and will be used against you. You have the right to an attorney. I will appoint the public defender's office to represent you, and you've got counsel seated next to you for today's hearing. State's asking for $25,000 concurrent bonds with pretrial services. Given the allegations here and history, I'll hear from defense.
Your Honor, excuse me, release Mr. Barnes' pretrial services. There's some factual issues here related to the case. Obviously, the incident date is listed as December 7th, and Mr. Barnes was not picked up for several weeks after the fact. The complaint makes note of the suspect that an eyewitness, which of course is not named or described, describes the suspect as a white man with brown hair in his 30s. While Mr. Barnes is a white man with brown hair, that probably applies to most people in Tucson. And Mr. Barnes is not in his 30s. They apparently recovered a driver's license. It's not clear from where the driver's license was recovered from, but at any rate, it has his birthday on it. And the officer would have known, had he checked birth date, that Mr. Barnes is not, in fact, in his 30s. He's younger than that. He is in his late 20s. So there's issues with the identification. There's issues with the length of time elapsed between these the incident dates. And then when Mr. Barnes was arrested, we don't know that it's the same person. And more to the point, there's no clear indication that Mr. Barnes is the person who is a suspect of this theft of means of transportation, because frankly, the only thing linking him to this apparent accident is a driver's license. And so how that driver's license got in this accident, or was perhaps even simply left in the street, wholly separate from this accident, is not something that's addressed at all in the complaint, and is some serious factual issues for the court moving forward. Now, given all that, Your Honor, I would ask that you release Mr. Barnes to the supervision of pretrial services. He'd be able to back in and remain in the community and defend himself from the outs rather than from in. So for these reasons, Your Honor, I'd ask that you release him to the supervision of pretrial services rather than impose the bond as asked for by the state. Thanks.
And pretrial, the report isn't available for me. Do you have it?
It should be available now.
There it is.
That's it up on me.
Right, I'm going to order a $25,000 bond. It'll be cash or secured, released to pretrial services if that bond is posted. I'm ordering that you do not drive. And no alcohol or illegal drugs, monitoring or treatment as directed by pretrial. Preliminary hearing date is January 9th. But sir, that hearing is very likely not going to happen on that date. You'll get a hearing at a later date. So if you do post the bond, you need to make sure that you are in contact with pretrial services and with your attorney so that you know when to get to court. And those will be concurrent bonds. All right. That's all, sir. You're excused.
Evans? Answer your shirt. That was.
Hi, sir. Can I get your full name?
Devin Kobe Evans.
Mr. Evans, I'm seeing you this morning on charges of possession of narcotic drug and possession of drug paraphernalia. You do have the right to remain silent. Anything you say can and will be used against you. You have the right to an attorney. I will appoint the public defender's office to represent you, and you've got counsel seated next to you for today's hearing. So state's asking for a $7,500 bond. There's an extensive felony history here and drug history. I'll hear from defense.
Certainly, Your Honor, I'd ask that you release Mr. Evans to pretrial services. It's, clear here that, with the quantity alleged and the, description of the actual events, what the officer has actually described is a personal use amount of possession of the drugs in question. And I've got serious concerns about the nature of the arrest. And so I frankly, Mr. Evans is not a threat to the community. He's not a flight risk here. And so I think checking with pretrial services is more than sufficient to ensure his participation in his case. And, in his defense moving forward, Your Honor. I will note that, the officer described this in the statement of probable cause. I think clearly trying to describe this as a for sale kind of situation. And it's very clearly not, given the quantity and the amount of money. And it's not even clear if the money and the drugs were in the same pocket. I would venture to guess they weren't. And so, for these reasons, Your Honor, I think that pretrial services is more than sufficient to ensure Mr. Evans' compliance with the court's orders and his participation in the case and the safety of the community as well.
Right. Given the failure to appear history, I am going to order just a $500 cash or secured bond released to pretrial services. If that bond is posted, monitoring or treatment as directed by pretrial, no alcohol or illegal drugs, don't return to that incident location. Preliminary hearing date is scheduled for January 9th, but that hearing is very likely not going to happen on that date. You're going to get a hearing at a later date. So if you do post that bond, make sure that you're in touch with pretrial and with your attorney so that you know when to get to court so that a warrant doesn't issue for your arrest. Do you understand, sir? All right, you're excused.
Real quick, Your Honor, is the public defender appointed?
Yes.
Yeah. Please tell me that I can't, that I won't, that I fail, that I'll never make.
Derek?
Hey, sir, can I get your full name?
Yeah.
All right, Mr. Garib, I'm seeing you this morning on some new felony charges of possession of dangerous drugs, possession of drug paraphernalia. And then I'm also seeing you on several warrants, one out of Superior Court for misconduct involving weapons, dangerous drugs, and drug paraphernalia from February 11th of 2023. And then it looks like you've got 2 warrants out of Pima County Justice Court, both for reckless driving, one of them from 2020 and one of them from 2022. And then failures to appear in court there resulted in the warrants. Let's see, on this felony warrant, pretrial says that it looks like you had not been previously arrested on that they sent a notice to you to appear in court. State's asking for $2,500 concurrent bonds on the felony matters. When I'll advise you that you have the right to remain silent. Anything you say can and will be used against you. You have the right to an attorney. On the felony matters, I will appoint the public defender's office to represent you. And you've got counsel seated next to you for today's hearing. I'll hear from defense.
Yes, Your Honor. I want to address the warrant issue first and foremost. It seems that the information that's been provided is that Mr. Jareb was in a medical crisis. It seems as though he was in a coma when the warrants were issued. That would certainly make it difficult to participate in one's case or have any knowledge of the warrants when they were issued. It's not clear as to what address they were sent to, or that Mr. Jareb was aware, at the time of his arrest or prior to his arrest when he was informed of the warrants, that he had warrants that were active. So, I would hope that the court can take that into account. I think pretrial services would be sufficient here, Your Honor. Again, we're talking about a insignificant quantity of drugs. What the police are alleging is less than a gram. And so, frankly, I think given the circumstances here, and maybe were they different with different history, that Mr. Jareb would be eligible for steps for SMART. So for these reasons, Your Honor, I'd ask that you give Mr. Jareb a chance, release him to pretrial services, allow him to check in and participate in his case from home on the outs rather than here in jail. Given the history and the circumstances regarding those warrants, I think that giving him the opportunity to clear those up and participate in his case is going to be the best thing moving forward.
Sir, where are you living right now?
With my aunt.
Okay. And she told pretrial that she could help you make sure that you get to court.
Yes.
Right. All right, on the felony warrant, I'm going to order release to pretrial services. Monitoring or treatment as directed by pretrial, no alcohol or illegal drugs, no firearms or weapons. And we've got an arraignment scheduled 1 week from today. That's January 6th at 1:30 in the afternoon. That's going to be in Superior Court with me. If you're not at that hearing, then I'm going to have to issue a warrant for your arrest, and you likely will not get out without a bond. Do you understand that? Then on the new drug charges, I'm going to order release to pretrial services. And preliminary hearing date is scheduled for January 21st. But so that hearing is very likely not going to happen on that date. You're going to get a hearing at a later date. Pretrial services and your attorney will help you make sure that you know when you need to get to court. So for now, that one hearing in 1 week from today, you have to get to that one, and then you're going to get future hearing dates after that. Right. And then on your justice court warrants, I'm going to order a release on your promise to appear there. And your hearing that you're going to need to get to is going to be in February. It's February 3rd at 9 o'clock in the morning in Pima County Justice Court. All right, sir.
Yep, thank you, Your Honor.
Welcome. You're excused.
Lopez.
Hi, sir. Can I get your full name?
Angel Karim Lopez.
Mr. Lopez, I'm seeing you this morning on a couple of different matters. You've got a new charge of fleeing from law enforcement. And then you've got a warrant out of Superior Court. A warrant out of Superior Court. Is for drug charges from April 21st of this year. And it looks like you're being held without bond on a probation violation out of Pima County Superior Court. And then you've got a warrant out of Marana City Court as well. All right, so on the new charges, the state is asking for a $15,000 bond plus pretrial services and $500 bond on the old drug charges. I'll hear from defense.
Certainly, Your Honor. Given the probation hold, I would ask that the court employs nominal concurrent bonds on the drug case and also the new charges. I can certainly appreciate the state asking for $500 on the drug case. On the fleeing from law enforcement charge, Your Honor, it's not clear to me how the law enforcement officers determined that it was actually Mr. Lopez who's driving this vehicle, just because it's registered to him or a vehicle they've maybe seen him driving previously doesn't necessarily mean that it's him in that particular date and time. He was arrested. Days later is what it looks like, something to the tune of a week later, and in a different location than what the incident location was listed as. It's not clear how fast that they're saying he was going, the circumstances of the the actual fleeing that they're alleging happened, or for how far or how they lost track of him. So for these reasons, Your Honor, I would ask that if the court is going to place a bond in the new case, that you do so concurrent with the drug case and that you keep that at a number that Mr. Lopez might be able to afford.
All right, on the new charges, I'll order a $7,500 cash or secured bond, release to pretrial services if that bond is posted. Do not drive without a valid driver's license, no alcohol or illegal drugs, monitoring or treatment as directed by pretrial. Preliminary hearing date is scheduled for January 9th. And then on the drug warrant, we'll order a $500 cash or secured bond and release to pretrial if posted. And arraignment is scheduled for January 6th at 1:30. And then on this Marana warrant, I'm going to order release, but you'll have a hearing today at noon since you're in custody on other matters on that. All right. You understand all of that, sir?
Yes, ma'am. So they're ran concurrent, right? They're all ran together.
No, they're separate bonds. $7,500 and a $500 bond.
So it'll be 8,000, you say?
Yeah, but you're also being held without bond. So if you would post that.
Probation.
Yep. All right. That's all. You're excused.
Moreno.
Hi, sir. Can I get your full name?
My name is Albert Murray.
Mr. Moreno, I'm seeing you this morning on a new charge of domestic violence, felony endangerment. And then I'm also seeing you on some misdemeanor charges out of Tucson City Court. We'll deal with those next. You do have the right to remain silent. Anything you say can and will be used against you. You have the right to an attorney. I will appoint the public defender's office to represent you, and you've got counsel seated next to you for today's hearing. Pre-trial, his report isn't up.
Let me send it back to review. It should be available now.
Got it, thanks. All right, state's asking for a $5,000 bond plus pretrial services given the allegations here. And he's also on probation. There was a probation violation warrant issued out of Tucson City Court for domestic violence charges as well. So I'll hear from defense on the felony.
Certainly. So Mr. Moreno has no prior felony history. I hope that the court would take that into account here. Given the circumstances here, it seems like there's some sort of fender bender is what the state is alleging occurred 4 times. It's not clear when or how or the circumstances of those impacts, though I will note that the charge is felony endangerment. And what the state would have to prove at trial is that Mr. Moreno recklessly endangered another person with a substantial risk of imminent death or physical injury. Your Honor, if there was some sort of car accident or some strike with the vehicle, that would have to be a very significant impact to cause physical injury or imminent death. And I don't think that the state has that here. What I think is probably more appropriate is misdemeanor endangerment or disorderly conduct or some charge of that nature. So given the circumstances here, I would ask that you release Mr. Moreno to pretrial services. He's got a place to live that looks like it's separate and apart from the alleged victim in this case. Are you working?
I'm starting work my first day on Thursday.
He begins work this week on Thursday, Your Honor. And so for these reasons, I would ask that you release Mr. Moreno to the supervision of pretrial services so that he can go back home, he can begin his job, stay out of trouble, and participate in his case.
I do my domestic violence sister as well.
All right, well, given the fact that I'm going to hold him on the petition to revoke probation out of Tucson City Court, I'm going to order a bond in this case. I'll make it a $2,500 bond. It'll be cash or secured. Released to pretrial services if that bond is posted. No acts of domestic violence. And do not drive without a valid driver's license. Preliminary hearing date is scheduled for January 9th. But sir, that hearing is very likely not going to happen on that date. You'll get a hearing at a later date. So if you do post these bonds, you need to make sure that you're in touch with pretrial and with your attorney so that you know when to get to court so that a warrant doesn't issue for your arrest. All right, on these city court matters, I'm going to read to you the petition to revoke your probation. It says that on August 8th of this year, you were adjudicated guilty of threats and intimidation. You were placed on unsupervised probation for 36 months. You were given written conditions of probation. The court was petitioned to revoke your probation because they said that you violated by failing to attend your review hearings with the court. And so a warrant issued for your arrest, it looks like on December 3rd. All right, so I'm going to enter denials of those allegations. And then I'm also seeing you on a new charge out of Tucson City Court as well. This is threats and intimidation from November 15th of this year. Oh, that one's not threats and intimidation. This is a dine and dash situation. So it's theft. And on that charge, I'm going to enter a plea of not guilty for you and advise you that you're ordered to appear at all of your hearings. If you miss your hearings, they can go forward in your absence. Warrants can issue for your arrest. And if you're convicted at a trial and you can't be sentenced within 90 days of the conviction, you could lose your right to a direct appeal. All right, on those matters, I'm going to order a $1,000 cash or secured bond. And I'll appoint the city public defender to represent you. If you are still in custody, you will be seen by Judge Blue on January 9th at 1:45. If you were to post these bonds, you would need to get to Tucson City Court on February 4th at 9:30 in the morning, or warrants will issue for your arrest. Do you understand all of that, sir? Okay, here, let me just change, Eric. I'm going to change what I just said. That February 4th date, if you wrote that down, you can cross that out. His hearing in city court is on January 9th at 1:45, whether he's in custody or out. Right?
Fritz.
Hi, ma'am. Can I get your full name?
Tennessee Lizette Perez.
Ms. Perez, I'm seeing you this morning on a new charge of endangerment, domestic violence offense that is alleged to have occurred on December 12th of this year. You do have the right to remain silent. Anything you say can and will be used against you. You have the right to an attorney. I will appoint the public defender's office to represent you, and you've got counsel seated next to you for today's hearing. The state is asking for a $2,500 bond, given the allegations here. I'll hear from defense.
Yes, Your Honor. So, Ms. Perez has a steady job. She works full-time as a caregiver. She has a home, a place to go to, a family to take care of. And so we're asking that you release her pretrial services. She has no listed misdemeanor history, no listed felony history. It doesn't, I'm not seeing so much as a traffic ticket to her name. So, for these reasons and the charges as they're brought, pretrial services supervision is more than appropriate here. I understand that it seems to be some sort of dispute between the officers listed in the complaint as to whether or not Ms. Perez was driving recklessly. The officer who filled this out did not observe the vehicle driving recklessly, though apparently officers not named in the complaint did. And so I think that there's a factual issue there. And just because somebody's driving recklessly, that doesn't necessarily mean that they are endangering somebody's life with a risk of imminent death or serious or physical injury. If that were true, then every single reckless driving charge would also be a felony level endangerment charge. And that simply isn't the case, Your Honor. It's not the case here. So for these reasons, I would ask that you release her to pretrial services.
Okay. What's your name, sir? Oh, okay. And you're the father of, okay. Can you come on over and let me know?
Your Honor, the state would like to be heard on this one before the court makes a decision.
Okay. Thank you. All right.
How you
Tell
doing?
me your name again.
Angel Gabriel Carrillo.
Okay. And you're the guardian of the child that was
Yes,
in the
ma'am.
vehicle. And what would you like me to know?
She's a good mother. They're just having like a dispute on this case right now, and it's like they need to just figure out what's going on because they've been coming for like 3 days in a row questioning her, and then yesterday they just came to pick her up out of nowhere. She lives with her grandma. She takes more than good care of my son when I'm working, and when she's working, I really need her help while I'm out here. I can't do it by myself, to be honest.
Okay. Thank you. I appreciate your input. Thank
All
you
right,
for being
thank
here.
you.
All right. Go ahead, Mr. Poston.
Neil, you're muted.
Still can't hear you.
Okay, how about now?
There you go.
What I'm seeing, Your Honor, here, this isn't a fact of her endangering somebody on the outside of the vehicle. This is the fact that she was driving in a highly reckless manner, allegedly over 20 miles an hour above the speed limit through residential areas, it would appear. And what I see here is the 4-year-old was in the car. So reckless driving doesn't necessarily involve risk to somebody outside the offending vehicle. That vehicle driving at that high rate of speed could have crashed, flipped, what have you, and that 4-year-old could have been injured. That is the nexus of the endangerment charges, not anybody on the outside.
Okay. All right, ma'am, I'm going to order that you be released to the third-party custody of pretrial services. I'm ordering monitoring or treatment as directed by them. Do not drive without a valid driver's license. And I'm going to order that you do not drive with your child in the car at this time. Do you understand that?
Yes, ma'am.
All right, and preliminary hearing date is scheduled for January 21st, but ma'am, that hearing is very likely not going to happen on that date. You'll get a hearing at a later date, so it's really important that you're in touch with pretrial and with your attorney so that you know when to get to court so that a warrant doesn't issue for your arrest. Do you understand?
Yes.
All right, you're excused.
Okay, thank you.
Redmond?
Thanks, you too. Hi, ma'am, can I get your full name?
Mariah Elizabeth Redmond.
Ms. Redmond, I'm seeing you this morning on charges of possession of narcotic drug, possession of drug paraphernalia. You do have the right to remain silent. Anything you say can and will be used against you. You have the right to an attorney. I will appoint the legal defender's office to represent you, and you've got counsel seated with you for today's hearing. So, ma'am, I'm looking at your history, and it looks like you've got no felony criminal history at all. So you're probably eligible for a drug diversion program where if you get to court and you participate in some drug treatment, you could have these felony drug charges dismissed before they're ever formally charged. Are you interested in that?
Yes, Your Honor.
Okay. We're going to set what's called a smart court hearing. That's in Superior Court on the 3rd floor. It's 1 week from today, January 6th at 9 o'clock in the morning. You have to be at that hearing so that you can participate in that program, okay?
Okay.
And counsel waive time?
Yes, Your Honor.
That'll be February 13th. And I'm ordering release to pretrial services, so you need to check in with them when you get out. I'm ordering monitoring or treatment as directed by them and no alcohol or illegal drugs. Right, ma'am? That's all. You're excused.
Right. Thank you.
So. Back again. Rideau? Yeah. You're up.
Hey, sir, can I get your full name?
Lloyd Rideau.
Mr. Rideau, I'm seeing you this morning on charges of possession of a dangerous drug, possession of drug paraphernalia. You do have the right to remain silent. Anything you say can and will be used against you. You have the right to an attorney. I will appoint the public defender's office to represent you. Sir, it appears that you may be eligible for a drug diversion program where if you get to court and you participate in some drug treatment, you could have these felony drug charges dismissed before they're ever formally charged. Are you interested in that?
Yeah.
All right, so we're gonna set what's called a smart court hearing. That's in Superior Court 1 week from today, January 6th at 9 o'clock in the morning. That's on the 3rd floor of Superior Court. And counsel waive time.
Yes, Your Honor.
So February 13th on the PH. And I will order that you be released to the third-party custody of pretrial services. You'll need to check in with them when you get out. I'm ordering monitoring or treatment as directed by them. No alcohol or illegal drugs. So you need to get to court in 1 week, sir, in Superior Court. That's all. You're excused.
Thank you.
Yeah.
Ma'am, can I get your full name?
Diane Rose Schmidt.
Okay, Ms. Schmidt, I'm seeing you this morning on a couple of different matters. You've got a charge of promoting prison contraband, and then a charge of possession of narcotic drug, possession of possession of narcotic drug and possession of dangerous drug. And then you've got some misdemeanor charges of shoplifting and drug paraphernalia. You do have the right to remain silent. Anything you say can and will be used against you. You have the right to an attorney. I will appoint the public defender's office to represent you, and you've got counsel seated next to you for today's hearing. State is asking for a $7,500 bond on the contraband matter and pretrial services on the possession matter.
Your Honor, more accurately, 7,500 concurrence.
Okay. All right, I'll hear from defense.
Certainly, Your Honor. So I'd be asking for pretrial services release in these cases. I'm taking a look here, and I would imagine that Ms. Schmidt might have possibly been eligible for Steps or Smart. Just the fact that there are 2 case numbers might have been the reason why she was not eligible. So given the amounts here, I would ask that you release her pretrial services so that she can participate in her defense from home. Again, these are very, very small quantities of drugs. In the prison contraband case, there's not even an amount listed. And so I would venture to guess we're not talking about very much at all. And given the circumstances and her cooperation with law enforcement, the statements that she made, in regards to that promoting prison contraband case, I can see and empathize with Ms. Schmidt being afraid. It is a scary process to be brought into jail and to be searched in the manner that she was. And so, the fact of the matter is that, what is being alleged to have occurred happened prior to her actually coming into the facility. And I know that that is not a reason for dismissal, but it's certainly something that the court can and very well should take into account in coming to a bond amount or release conditions here. I think pretrial services is more than sufficient to ensure her participation in the case here today.
Your Honor?
Sure.
It absolutely defies logic to state that she did not know that she had these drugs given where found. Additionally, these are the sort of charges that every time somebody actually does successfully get drugs into the prison and to the jail and overdoses, there's an absolute screech from the community as to somehow it is not the individual's fault. What I'm seeing here is these drugs, the fact is bringing drugs into the facility needs to be criminalized. This needs to be strictly enforced because the state does have this obligation to see to it that this poison does not get into the jail. To go ahead and give this pretrial release basically ratifies the lack of enforcement of a mandate that, when not enforced, results in more community outcry. 7,500.
I'm going to order that you be released to the third-party custody of pretrial services. I'm ordering monitoring or treatment as directed by them, no alcohol or illegal drugs. So you need to make sure that you check in with pretrial services when you get released. And your preliminary hearing date is scheduled for January 21st. That hearing is very likely not going to happen on that date. You're going to get a hearing at a later date. So it's really important that you're in touch with everyone so you know when to get to court. Do you understand that?
Yes, ma'am.
Right. And then as to the misdemeanors, I'm going to order release on your promise to appear in court. I am ordering that you not return to that incident location. Again, no alcohol or illegal drugs. Your hearing that you will need to get to in justice court is January 29th at 8:30 in the morning. Do you understand all of that?
Yes, ma'am.
All right. You're excused.
Thank you.
Simmons.
Hi, sir. Can I get your full name?
Kevin Morrison, Claiborne.
Mr. Simmons Claiborne, I am seeing you this morning on a few different matters. You've got a felony warrant for dangerous drug, narcotic drug, drug paraphernalia from September 7th of this year. And then you've got some warrants out of Tucson City Court. We'll deal with those next. Let me just take a look at what happened here with the felony. So it says that you were released to pretrial services and did not stay in contact with them and didn't get to court, so a warrant issued.
Your Honor, just as a point of information, was Mr. Simmons initially scheduled for a different IA day? Because I don't have the complaint or the state's recommendation for this case.
It's just $500, a $500 bond. That's what I put on the warrant in January, or in just, it looks like a few weeks ago. And it says he was originally arrested back in September, was released to pretrial, and then the summons was mailed to him and he didn't appear on the 4th.
Last night, 6 months. Just came back. I didn't know. 2 months ago, $16 back.
And there's also new charges in city court, as well as a couple of warrants. All right. So I'm inclined to just do the $500 bond and then a small bond on his city court matters. Did you want to be heard on that?
Yes, Your Honor, I would just ask that the court is going to place a bond that you do so in a nominal amount, such that Mr. Simmons Claiborne might be able to afford The information I have is that the warrants and the court information was mailed to his grandmother's house. She was out of town for an extended period of time in California. And so it's not clear to me that Mr. Simmons-Claiborne had access to the mail at that home. It being a family member's mailing address, I mean, that gets to be a little difficult if the person's not there, and it seems like his grandmother was not. So, it's not clear that he had information as to the, his court dates or the fact that warrants, had been issued. So given that information, Your Honor, I would just ask that you keep the amount low if you're inclined to in place a warrant. Again, I don't have a lot of information on the new charges or the old charges because I don't have the complaint, but I just want to say that, I would ask that you give him the opportunity to participate through pretrial or post a very nominal bond if you're inclined to do so.
I'm going to order a $500 cash or secured bond released to pretrial if that bond is posted. Monitoring or treatment as directed by pretrial. No alcohol or illegal drugs. Public defender is appointed. Arraignment is scheduled for January 6th at 1:30 in Superior Court. All right, on the city court matters, the new charges are obstruction, criminal trespass, and drug paraphernalia. And then there are warrants for drug paraphernalia, criminal trespass from October 13th of this year, and drug paraphernalia from June 9th of this year. Right, you do have the right to remain silent. Anything you say can and will be used against you. I'm going to enter pleas of not guilty for you on these new misdemeanor matters and advise you that you're ordered to appear at all of your hearings. If you miss your hearings, they can go forward in your absence. Warrants can issue for your arrest. And if you're convicted at a trial and you can't be sentenced within 90 days of the conviction, you could lose your right to a direct appeal. On those matters, I'm going to order that you be held on a $250 cash bond. Don't return to any of the incident locations. No alcohol or illegal drugs. And city public defender is appointed to represent you there. You'll be seen by video on January 7th at 1:45. If you were to post your bonds, you would need to get to Tucson City Court on January 29th at 9 o'clock. You understand all of that, sir?
Yeah, I'm confused on paraphernalia and different other charges because I haven't been stopped or anything to acquire any new charges. It's the first time that I've been having any type of any infraction with law enforcement since.
You've got several cases, one from June, one from October. You were previously arrested. It looks like I actually released you in September. So you've been to court before and then you're not getting to your court date. So that's why you've got warrants. So now you're gonna, if you stay in custody, they're gonna take you to video hearings to deal with all of these, okay? All right, you're excused.
Cesar Vega. Sure.
Hey, sir, can I get your full name?
Eduardo Vega.
Mr. Vega, I'm seeing you this morning on a couple of different matters. You've got new felony charges of possession of narcotics and possession of drug paraphernalia. You do have the right to remain silent. Anything you say can and will be used against you. You have the right to an attorney. I will appoint the public defender's office to represent you. We've also got a Tucson City Court warrant that we'll deal with next. As to the felony charges, the state is asking for a $1,000 bond. I'm seeing no felony history, should be eligible for steps. I'll hear from defense.
Yes, Your Honor. Given the lack of felony criminal history and the fact that this is eligible for steps or smart court, Mr. Vega is given an opportunity here to right the ship and turn things around. I would ask that the court release him to pretrial services so that he can participate in the SMART program and do so from home, with his family and the community support that he has. What we're talking about here is a couple drug cases and then a looks like a misdemeanor for failing to remain at the scene of an accident. So given the circumstances here, the quantity alleged, which is officers note 6 pills is what they had recovered. And so given those circumstances, I would ask that you release Mr. Vega to pretrial services so that he can participate and turn things around moving forward.
All right, so sir, it appears that you are likely eligible for a drug diversion program where if you were to go to court and participate in some treatment, you could possibly have these felony drug charges dismissed before they're ever formally charged, which would be really great for you considering your lack of history, felony history. Are you interested in that?
Yes, ma'am.
All right. So I'm going to order that you be released to pretrial services supervision. I'm ordering monitoring or treatment as directed by them. No alcohol or illegal drugs. We'll set a smart court hearing. You need to be at this hearing 1 week from today on the 3rd floor of the Superior Court, January 6th at 9 o'clock in the morning. If you don't go to that hearing, then you can't be eligible for that program. Do you understand that?
Okay.
And counsel waive time,
Yes, Your Honor.
February 13th on the PH. All right, and then on this city court warrant, this is for failure to remain at the scene of an accident from back in 2022. So you still need to get to Tucson City Court to deal with that matter. That hearing we will set for January 30th at 9 o'clock in the morning.
Okay.
You have to get to that hearing or another warrant is going to issue for your arrest. Do you understand? Right, and I'm also ordering that you do not drive without a valid driver's license.
Okay.
All right, sir, that's all. You're excused.
Thank you. Vega Padilla.
Hey, sir, can I get your full name?
Arturo Vega Padilla.
Mr. Vega Padilla, I'm seeing you this morning on a number of different matters. You've got new felony charges of possession of a narcotic drug, possession of a dangerous drug, and possession of drug paraphernalia. And then you've got warrants. A warrant out of Superior Court for narcotic drug paraphernalia from January 30th of this year. And then warrants out of Justice Court, one warrant out of Justice Court for a 2020 DUI. And then one out of Tucson City Court for drug paraphernalia from 2023. You do have the right to remain silent. Anything you say can and will be used against you. You have the right to an attorney. I will appoint the legal defender's office to represent you, and you've got counsel seated next to you for today's hearing. Looks like there is a federal detainer. So let's see, state's asking for $500 or $1,000 bond on the old drug charges and a $5,000 bond concurrent on the new drug charges. I'll hear from defense.
Yes, Your Honor. I'd ask for the $1,000 bond concurrent in each. Given the the federal detainer hold, we're not sure how long that would take to resolve. We just want to make sure that he's given the back time that he's due if he's being held here in the jail, and if that federal detainer does get lifted, Mr. Vega Padilla would like to be in a position in which he might be able to actually afford to post the bond and put up the collateral required so that he may secure his release. And to do so, the court needs to take into account his financial circumstances. $1,000 would be a significant amount of money for Mr. Vega Padilla. He's self-employed as a musician, And so for these reasons, Your Honor, I'd ask that you in place that nominal $1,000 concurrent cash or secured bond so that he's able to build that back time and potentially secure his release once that detainer's lifted.
I can't do concurrent bonds in these two cases since one of them is still pre-indictment and under the jurisdiction of justice court. So I will order $1,000 bonds. They'll be cash or secured, released to pretrial if posted. No alcohol or legal drugs, monitoring or treatment as directed by pretrial. There's an arraignment scheduled for January 6th at 1:30. And then on the warrant, or no, the new charges, that'll also be $1,000 bond, cash or secured, released to pretrial if posted. And Mr. Postner, we'll set a smart court hearing? You're muted. Still muted.
All right, for some reason, it's not working this morning. Can you hear me?
I can hear you, thanks.
The state would go ahead and say yes, schedule the smart hearing, and let's see if we can work it out.
Okay, sounds good. So we'll set a smart court hearing for January 6th at 9 o'clock. We'll make the preliminary hearing January 9th. All right, and then on the justice court warrant, we'll make that a $100 cash bond. I'll appoint Janet Altschuler. And do not drive without a valid driver's license, no alcohol or illegal drugs. Your hearing in justice court will be tomorrow, the 31st at 1 o'clock in the afternoon.
Okay.
And then city court. This is drug paraphernalia from 2023. On that one, I'm going to order that you be released, but I'll note that you're in custody on other matters. We will set a non-transport review for February 7th at 9 o'clock in the morning. If you are out of custody by February 7th, you're going to need to get to Tucson City Court at 9 o'clock or warrant will issue for your arrest. If you're still in custody, they'll just have that non-transport review at that time. And I will appoint the city public defender to represent you. All right, sir, that's all. You're excused. Hi, sir, can I get your full name?
Timothy James Westbrook.
Mr. Westbrook, I'm seeing you this morning on a charge of unlawful use of means of transportation. You do have the right to remain silent. Anything you say can and will be used against you. You have the right to an attorney. I will appoint the public defender's office to represent you. And you've got counsel seated next to you for today's hearing. State's asking for a $7,500 bond given the history. I'll hear from defense.
Yes, Your Honor. with this case, what's being alleged is there's some sort of dispute about how long Mr. Westbrook could have the car. He was, apparently had the car for longer than what he had agreed and what he paid for, which is apparently what is being alleged here in the complaint. It seems the vehicle was recovered. There's no damage that's being claimed. What we're talking about here is unlawful use of means of transportation. I would ask that you release Mr. Westbrook to pretrial services, or if the court is inclined to impose a bond, a nominal one such that he might afford. Mr. Westbrook is a man of limited means. And so his financial circumstances that the court needs to take into account in coming to a bond amount. Here we've got, not a crime of violence, a crime, a property crime in effect that the victim, it does not seem, was financially harmed because of the any damage to the vehicle. The amount of time that it was claimed to have been missing was just a matter of a couple of days. And so for these reasons, Your Honor, I'd ask that you consider releasing Mr. Westbrook to pretrial services or impose a nominal bond if the court is so inclined.
I'm going to order a $1,500 bond. It'll be cash or secured, released to pretrial if posted. Monitoring or treatment is directed by pretrial. No contact with the alleged victim. And we'll set a preliminary hearing date for January 9th. Sir, that hearing is very likely not going to happen on that date. You'll get a hearing at a later date. So if you do post that bond, make sure you're in touch with pretrial and with your attorney so you know when to get to court. That's all, sir. You're excused. Hi, sir. Can I get your full name?
Christopher Whitehorse.
Mr. Whitehorse, I'm seeing you this morning on a few different matters. You have a new charge of aggravated DUI, and then you've got a warrant, a felony warrant for 2 counts of aggravated assault with a deadly weapon or dangerous instrument that are alleged to have occurred from May 11th of this year. And then you've got a warrant out of Justice Court for DUI from 2022. You do have the right to remain silent. Anything you say can and will be used against you. You have the right to an attorney on the felony matters. Will appoint the public defender's office to represent you, and you've got counsel seated next to you for today's hearing. State's asking for a $15,000 concurrent bond plus pretrial services, and I do think that I can order concurrent bonds in these cases because they're both pre-indictment. Mr. Poston, do you have any information on the warrant case? Is it DUI related or is it something else, or do you not know?
Your Honor, if I'm not mistaken, can you hear me?
Yes.
Okay, what I see is ag assault deadly weapon. The pretrial website was fairly scarce as far as this one goes, but what I see here, most current one, we have the ag DUI, and then we have the other felony, which I see as ag DUI, ag assault with a dangerous weapon. There was deputies encountered somebody that apparently was fleeing the defendant, his former girlfriend. He was armed with a handgun, and when he was confronted apparently by some construction workers who were trying to figure out what was going on, or at least encountered some construction workers. He pointed the weapon at them and told them not to call 911. He then fled into a uninhabited desert area. Suffice to say, it looks that to be in the May case, there was originally a request for a $50,000 bond. What we're seeing here is he was chasing his girlfriend or ex-girlfriend with a weapon. He pointed the weapon at some workers that were in fact witnesses and demanded they not call 911 and kept pursuing her. This is rather disturbing, Your Honor, and given the two, $15,000 concurrent is appropriate in the state's opinion. And I would note in the Ag DUI, he was quite combative. The police actually had to essentially hogtie him to get him into the vehicle and get him processed.
All right, and I'm seeing a $75,000 bond on the felony warrant ag assault matter. It looks like they passed out the 50 and upped it to 75. All right, I'll hear from defense.
Yes, Your Honor. I really can't address any of the allegations or the editorializing that the state is engaged in here on the ag assault charges because I don't have that complaint. So I cannot really meaningfully address those allegations, though I will note that, you know, as for the DUI here, it's not clear to me when Mr. Whitehorse's license was suspended or for what reason precisely. The prior DUI is from some time ago. And so I would ask, Your Honor, if the court is inclined to impose a concurrent bonds here, that the court impose a nominal bond given the, you know, the two different cases here, the fact that they're both pre-indictment, the court can indeed impose concurrent bonds, that you do so at a number that Mr. Whitehorse might be in a position to afford, given his financial circumstances here. I can certainly understand that we're talking about very serious charges. Thing I would note is that Mr. Whitehorse is a younger man. He's got opportunities to turn things around, and so participating, in his defense from the outs, if he's able to actually post that bond, would be a significant benefit to himself. In addition, Your Honor, putting a number that he might be able to afford ups the ante and provides a serious financial incentive to participate and comply with the strictures of and supervision of pretrial. So for these reasons, Your Honor, we're asking for a nominal concurrent bond in these cases.
Your Honor?
Yes.
I would note, and I will quote the interim complaint, the driver was positively identified as Christopher Whitehorse, whom a records check showed his driving privilege being suspended for a prior DUI, and additionally showed multiple felony warrants, one being for DUI. So it was clear why the person's driving privilege was suspended, notwithstanding prior statements. State submits on the aforementioned.
Thank you. All right, I'm going to order $25,000 concurrent bonds on the two felony matters and release to pretrial services. If those bonds are posted, do not drive without a valid driver's license, no alcohol or illegal drugs, no firearms or weapons. Monitoring or treatment as directed by pretrial. Preliminary hearing date on both matters is scheduled for January 9th at 1:30. And on the ag assault charges, ordering no contact with any victims. And then on the justice court warrant, I'll order a $100 cash bond on that. I will appoint Robin Ald to represent you in justice court. You'll be seen tomorrow, the 31st at 1 o'clock in the afternoon on that matter. And same release conditions. All right, sir, that is all. You're excused.
Thank you, Judge.
All right, thanks everybody. Have a great day.
Thank you, Judge. You as well.
Peace.